conservatory orders, the locus classic case of Gatreo Peter Monya, which I've said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also cited the case, the court in Wilson, Kaberia, Nkunja. You'll find them in our ruling. Having considered those, then what we then looked at are the elements for granting a conservatory order. These are, we are giving them to you in point form, but we have discussed them in detail in our ruling, which we shall give. For the sake of completeness of the record, we have dealt with the merit of the application and whether conservatory orders should issue, whether prima facie case has been established. We take the view that the same has been established. The applications raise constitutional issues that require further judicial interrogation. Whether any prejudice will be suffered by the applicants. No prejudice if the applications are not granted at this stage. The process is a lawful constitutional process, and the Senate will conduct a trial where all the issues being raised before the court will be raised and determined. At the moment, we are being called upon to anticipate the outcome of a process yet to be completed. The application at this stage is premature and anticipatory. Should the petitioner not succeed, the petitioner still have an opportunity to approach the court after the process. The applications are not without a remedy. On the issue that has been raised that as soon as the Senate impeaches the DP, if at all that happens, that the DP immediately ceases holding office and he cannot reclaim office, we take the view that every office holder can only assume office legally and constitutionally. The assumption of office cannot oust the court's jurisdiction. The court has unfettered jurisdiction to check on the constitutionality of the process at whatever stage. Whether the grant or denial of the conservatory order will enhance the constitutional values and objectives in the Bill of Rights. We find that exercising restraint at this stage will enhance and allow independent institutions of government to function unhindered and in their fullness, except in the clearest of cases. It is our view that this is not one such case where intervention is automatic. The issues raised by the parties will require to be interrogated. We therefore find that the enhancement of the constitutional principle of separation of powers will be best served by declining the application at this point. Whether the petition will be rendered nugatory, we find and hold that it will not. The petitions challenging the process of impeachment, the petitions are challenging the process of impeachment. The substratum of the petitions will not be lost. The court is still able to grant a remedy even after the process is conducted, even after the process is concluded, and as such, the court will not be acting in vain. On public interest, we find that the public interest tilts in favor of allowing the constitutional process to proceed unhindered. Disposition, therefore, deriving from the foregoing, the following final orders do issue. The consolidated applications are hereby disallowed, caused to abide the outcome of the main petitions. That is the